Probate is an umbrella term that deals with the legal process when someone passes away. Their assets need to be sold or transferred, and liabilities need to be paid, and the remainder then distributed in accordance with their will. For those with a valid will, the executor will be the person dealing with the probate process. The umbrella term probate comes from a document called a grant of probate, which is issued by the probate registry. The grant of probate lists the people who may administer the deceased's assets. Assets of a certain value may require the need for the grant of probate in order to sell, cash in, or transfer them. When a person dies without a valid will, they are said to be intestate, and the statutory rules of intestacy will apply to their estate. The intestacy rules are rigid and inflexible. Your estate will pass to specific people regardless of your wishes, and may also have adverse tax consequences for your estate. There are limitations on what passes to spouses. It's not always the whole estate. The person who deals with the estate is called an administrator. They are required to obtain a grant of letters of administration, similar to a grant, in order to administer the estate. It's not always the person that you think it might be. If you know someone who has died without a will, you may not be sure who should deal with the estate and what they are permitted to do. We can advise you as to who is entitled to apply for letters of administration and who is due to benefit. Before applying for probate, sometimes referred to as letters of administration, it is always worth checking that the size and nature of the assets within the estate are such that probate is needed and you are eligible to apply. The process will then involve having all jointly and solely held assets and liabilities valued as at the date of death, and considering whether an inheritance tax return is necessary and whether there is any inheritance tax due to be paid. Once the inheritance tax position has been ascertained, information relating to the deceased and the executor is put into a document called a legal statement, and this is submitted to the probate registry together with a will, if there is one. Probate can then be granted. The timescales for getting probate can be a few months. We act for executors and administrators to assist them with administering the estate, working out inheritance tax payable, and distributing assets correctly. We offer fixed fee costs for simple probate matters, and following a detailed meeting can give you a better cost estimate for more complex matters. Legal costs are usually paid from funds within the estate. When we are referring to probate, if we mean the entire process, from investigating the deceased estate, establishing the inheritance tax position, obtaining the grant of probate and distributing, then this can take sometimes up to 12 to 18 months depending on the complexity. However, if you are referring to times for simply applying for a grant of probate, then from the point of application to the grant being issued, this can take 3 to 4 months, but this could be longer for more complex applications. Just because you are a beneficiary doesn't mean you have to take your inheritance. It may increase the value of your estate for inheritance tax purposes, and you may not need all or part of the funds. Redirecting your inheritance using a deed of variation is a good planning opportunity. For example, a parent may wish to redirect money to their children or grandchildren. By executing a valid deed of variation within 2 years of the date of death, the gift will be treated as though it came from the deceased's estate and not from the beneficiary's estate. A deed of variation can be created whether the deceased left a will or died intestate, and can be used to create trusts as well. If you are not happy with the content of a will, how the intestacy rules apply, or how someone else is administering an estate, then we have a separate team that can assist you with this. Start the probate process today using our online form found on our website, or alternatively, call and schedule an appointment with one of our probate law team.